So welcome everybody. Thank you for joining us today. I appreciate the introduction, Larry. It was a real pleasure working with you in the past, and I appreciated the invite to come and speak to people. I haven't done too many presentations since COVID, and we've done a couple of Zoom presentations here and there, but we had been doing this regularly, and it's nice to get back to it a little bit. So I'll dive in just a little bit. What I will say is just to repeat what Larry had talked about, because I see Mary has a question about it. In the chat window, there should be a chat from myself. And if everybody can see that, there's my chat box is a link. That link should open up a PDF document. And that document is just a way to follow along with what I'm going to be talking about today. You having trouble with it, Mary, still? I'm going to resend it.
Okay.
Okay, I see the link now. Thank you.
I suspect that maybe it didn't work for people who signed on after I had sent it earlier. So it's there. You're welcome to take a look at it. It's just an easy way to kind of follow along with some of the topics that I'm going to be talking about. It's not necessary. It's not very in-depth. It's really just a guideline a little bit. But what I wanted to talk about Can everybody hear me again now? I think I'd been muted for a little half a second. That's all right. I'm good. We'll get there. So what Larry had asked me to come in and talk about was estate planning, as he mentioned. And it's always helpful, I think, to kind of go over the basics and just to be able to start with what a lot of questions or a lot of people ask me questions about. And I've been practicing now for 17 years. I've been doing estate planning work for 15 of those. And I've really had the opportunity to work with a lot of different people in a lot of different situations. And the way I've kind of structured this talk and structured the handout that you have is around what I find everybody needs, what most people need, what some people need, what many people need, and what some people need, right? So I want to kind of talk about those four categories today, starting with what everybody needs and working down to what only a few people need. And then at the end of that, I'm going to talk about two specific issues that I have a lot of clients be concerned about, and that's estate taxes and thinking about estate taxes and planning for mass health the need for nursing home care and how to pay for it using the assistance that mass health and Medicaid can help provide. So that's the basic outline of what I'm going to talk about. But I always do like to start with the documents that everybody needs, right? If you're thinking about doing estate planning, everybody over the age of 18 really should have two documents in place. And those are a healthcare proxy and a power of attorney, right? Many people are already familiar with these documents. They may be named as a healthcare proxy for somebody or as a power, a power of attorney for somebody else, or you've possibly executed these documents and signed them for yourself before. A lot of times your doctor will talk about this. If you end up in the hospital, if you're going into the hospital for something scheduled, the hospital or medical providers will often have you sign a healthcare proxy that's just covering that period of time. But the two documents are very similar to each other. So the healthcare proxy and the power of attorney documents are two documents that allow people to make decisions and take actions on your behalf. The healthcare proxy document allows people to make medical decisions for you, and the power of attorney document allows people to make financial and real estate decisions for you. So these documents are only effective for as long as you're alive, right? Once, if you're incapacitated, the classic example is you're in a car accident and you're in a coma in the hospital, or you've had a stroke, and you don't have the ability to communicate what your wishes are, or even to determine what those wishes are. If you're completely incapacitated, you may not even have any awareness of what is going on around you. So if you don't have that capacity or are unable to communicate your decisions, you've got to have people who can make those decisions and enforce them for you as if you were able to. So that's what the healthcare proxy and durable power of attorney do. The healthcare proxy allows people to make those medical decisions for you, and the power of attorney allows people to do those financial and real estate documents. And a lot of times, as I mentioned, people will have filled out healthcare proxies from their medical providers. Those are often perfectly fine. I always like to review them for my clients just to make sure they're adequate. The two things I'm always looking for in a healthcare proxy are that they have at least two people named, a primary healthcare proxy and then an alternate in case that primary is not available, right? So if you have a healthcare proxy that you've already completed at one point with your medical providers or your doctor, pull it out, take a look at it, make sure that you've got a backup as well, because if something's happened to the one person you've named, then you're stuck. You're in the same boat that you would have been if you hadn't even done the healthcare proxy. And the second thing that I always look for in a healthcare proxy form is language regarding the waiver of HIPAA. HIPAA is the federal law that protects patients' privacy. And I always like to see an extra statement or paragraph in a healthcare proxy document that says, I, the person signing this healthcare proxy document, am specifically waiving those HIPAA protections when it comes to my healthcare agent. I want them to be informed of all the information that my doctor has, right? So those are two things that I'm always looking for when I see those forms. So if you have those already filled out, pull them out and see if they're there. And if not, I'd be happy to talk to you about it a little bit more. When it comes to the power of attorney, there are less forms around about those. Those aren't as easily available as healthcare proxies, but they're really important, especially for, a lot of times married couples will think, well, I don't need a power of attorney. My spouse will just take care of everything. But as I mentioned, if something's happened to your spouse also, you need a backup just in case something's happened to both of you. And also, what a lot of people don't realize is even if you co-own property, real estate, if you co-own real estate with your spouse and your spouse is incapacitated, you're not going to be able to take action regarding that real estate. You're not going to be able to mortgage the property if you need funds. You're not going to be able to sell the property if you want to get rid of the property without a power of attorney allowing you to act in your spouse's name. Okay. So even for marriage, a lot of times I'll be meeting with people and they'll say, oh, well, we own everything jointly, including the house. And so we don't need a power of attorney. It's not the case, and definitely still need that in place. And the reason why you need these in place, the healthcare proxy and the power of attorney, is because if you don't have these and then you become incapacitated, the only option for your family is to go to probate court and to have a conservatorship or a guardianship appointed, right? So a guardianship is the equivalent of a healthcare decisions, and conservatorship is the person, or a conservator is the person who would be handling your finances. But if you don't have the healthcare proxy and power of attorney documents, your family and friends have to go to court to get that appointment in order to have the authority to make those decisions. And that's a time-consuming and costly process. We usually tell people it's, pre-COVID, it was taking anywhere, Hampshire County is a little bit better. Hampshire County Probate Court is a lot better than Hampden County Probate Court. But even pre-COVID, it was 2 to 4 weeks, on an emergency basis. And $2,000 to $3,000, right? And it's a lot more expensive than if you just have a healthcare proxy and a power of attorney executed. Those documents would fulfill those roles. So those are the two things that really everybody over the age of 18 should have a healthcare proxy and power of attorney, no matter what. So the next category, what most people need. The first thing that I have listed here is a last will and testament. And people are often surprised by this. They think that a last will and testament's always needed. There's a couple of specific circumstances where I'll meet with clients and it's probably not necessary for them to have a last will and testament. Not many people fall into this category, which is why most people need a last will and testament. But occasionally, if you have a very, very simple estate where your estate, what the assets that make up your estate are very simple, and you have a very simple family situation, maybe you have 1 or 2 kids, you're not concerned about how they're going to take assets, you're not concerned about them receiving their share of the inheritance when you pass away. So if you pass away without a last will and testament, if you don't have that document in place, there are state laws that govern where your estate's going to be passed to. So if you have a very simple estate situation and a very simple family situation and simply want your estate to go to the same people that the state law says, every once in a while, I will say to somebody, don't worry, you don't need to worry about a last will and testament. We can still do one if you want to, but we don't need one. and it, allows them to save a little bit of money in the drafting, but that's rare. Most of the time, having a last will and testament is really beneficial. It allows you to make specific bequests of any money or items that you want. It allows you to hold money for certain purposes or pass money down to people who wouldn't be entitled to receive your assets under the state law. If you want to include other family members or other, friends, even, if you have somebody that you want to make sure receives a piece of your estate, if they're a neighbor or a second cousin, they're not going to do that under the state law. You need to have a last will and testament that says, before when I pass away, this is how I want my estate to be split and where I want it to go. And that's all necessary. Okay. The last will and testament, also having a last will and testament written and executed, also gives you the opportunity to name somebody called the personal representative. So that is the new fancy term for executor, right? Everybody knows what an executor is. An executor is just the person who handles your estate when you pass away. About 12 years ago now, almost 13 years ago now, the state legislature changed all the probate laws and all the probate rules, including changing the name of executor to personal representative. So it's exactly the same thing. They just decided to ignore 400 or 500 years worth of history and confuse everybody. So I always want people to know that it's the exact same thing. If you ever see the term personal representative in the context of a last will and testament, it's the same thing as an executor. But having the document written and executed allows you to name the people you want as your personal representative, as the executor for your will. And that's sometimes important because you want to make sure that you're naming people that you would really trust in that position to handle your estate after you've passed away. And that allows you to identify for the court the people that you think are most and best suited for that. Okay. So that's why a last will and testament is almost always necessary. Anytime we're dealing with slightly more complex estates, it's absolutely necessary. So it's very rare that I tell somebody that it's not. Something else that most people need is a declaration of homestead. So if you own real estate, if you own your primary residence, then you really want to make sure you have a declaration of homestead in place. If you're renting or living in an assisted living facility, it's not necessary. But if you own your own real estate, that declaration of homestead provides a lot of extra protection for you and your spouse and your heirs when it comes to potential creditor claims, right? So in brief, there's a state law called the Homestead Protection Act. And the law itself provides protection of $125,000 of the equity in your house against personal debt. Okay, so personal debt, if as examples, if you have some credit card debt, or if you get into a car accident and the insurance doesn't cover it, if you get sued, if you owe somebody some money for whatever reason, they can take that, they can sue you and then take that and reduce it to a judgment, and then they can enforce that judgment against assets that you own, including real estate. And the whole idea behind the Homestead Protection Act is that the state legislature doesn't want people to be forced to sell their primary residence, their homestead, in order to satisfy those debts, right? So they provide automatic protection of $125,000 of equity. But if you sign and record a declaration of homestead at the Registry of Deeds, then that declaration of homestead provides additional protection of up to $500,000 and up to $1 million if you're over the age of 65 or disabled. So to the extent that you own real estate, having a declaration of homestead provides a lot of protection in case you're ever sued for any reason. So most people need that. Certainly if you have real estate, it's something that we want to make sure is in place for everybody. So then we talk about what many people need. And the first thing that I talk about here is something called a MOLST form, right? MOLST form stands for Medical Orders for Life-Sustaining Treatment. And these are important. These are used along and in concurrence with your healthcare proxy document, right? Your healthcare proxy document allows people to make decisions for you, but they're really designed for moments when there's a little bit more ability to make those decisions. When your doctor or even an emergency doctor is going to somebody to ask, what should we do next, right? Like here's this person's situation. What action should we take? do we need to, should we do this surgery? Should we not do this surgery? Should we provide this care? Should we not provide this care? That's what that healthcare proxy is for. The most form is designed for split-second decisions, right? Your most form is designed to provide immediate guidance to essentially emergency responders as to your wishes when it comes to extraordinary medical care, resuscitation, essentially, right? They're often in red or pink, so that way they are very visible. And what they are designed to do is to be, they're designed to be visible, and they're designed to be kept either on the person or close to them. Oftentimes people will stick them right on their refrigerator. So that way, if there's a situation where emergency responders are rushing through because somebody has had a heart attack or some other medical crisis, those emergency responders can immediately see this person has already executed a medical order for life-sustaining treatment, and they'll take a quick glance at it to see what that person has said they want or don't want when it comes to emergency resuscitation. So because these are such important, these are documents that are designed for very important moments, and for very quick decisions that really can't be undone sometimes. They are a little bit more in depth in that they require discussion with your medical provider. As an estate planning attorney, we help you prepare healthcare proxies. The most form has to be prepared and signed off by your physician. It has to be signed off by somebody who is in charge of your medical care, an actual doctor who you have a relationship with. So that's to make sure that that doctor has spoken to you about what the repercussions of those decisions are, right? The decisions to not receive resuscitation or to not receive emergency care are, life altering, obviously, and they're difficult to make. So that's why it requires your physician's involvement. So I list them here because they're very important estate planning documents for people who are in the position where they're considering that, but it's something that not something that our office does. It's something that we just discuss with our clients. So something else that a lot of people need, many people need, is different types of trusts. So you can see if you have the handout in front of you, I just talk about trust in general. The great thing about trust is that there are lots of different types of trust because there are lots of different reasons that we use trusts. So I'm not going to go into all of them right now. We're going to talk about a couple of different types of trust, a couple of different specific types of trust used for very specific purposes. But I just wanted to talk about that here because it's often as a result of people's financial situation and the status of their estate, it's often useful to have a trust in place. Sometimes we use trust or just to provide some guidance and control over your assets after you've passed away. If you have, a kid or a grandkid who you want to inherit some money, but you're concerned about their spending, or you're concerned about, maybe they're in the middle of a divorce or a bankruptcy, or they're in the high risk field where they're likely to get sued, you may not want to have them inherit all of their share of your inheritance directly. Because if you simply say here, after you've passed away, if your estate simply passes directly down to that person, it's their money, and then it's at risk, right? If they get divorced, it's potentially going to be lost to half of it could be lost to a spouse. If they get sued, all of it could be lost. So oftentimes we will use a trust just to provide our clients with some control over those assets after they've passed away, where they can say, this money's available for my beneficiaries, my child perhaps, but it's not fully theirs, right? There's some limitations. And then at that point, you have some ability to say, sorry, even though we're getting divorced, I don't have access to that trust. So you don't have access to that trust either, divorcing, spouse, my soon to be ex-spouse. So that's one common trust that we use. Oftentimes we often talk to clients about using trust to avoid probate. I talked about a last will and testament a minute ago. A last will and testament itself doesn't avoid the probate process. It just guides the probate process. It directs the probate process. Ultimately, after you've passed away, a probate administration, a state administration, has to occur for any assets that you own individually when you pass away. If If you own something jointly, if you own depends on most of the ways you would own something jointly, but if you had a jointly owned bank account, the funds are going to go to the surviving owner. But if you own a bank account by yourself and you pass away, those funds have to go through the probate process. The last will and testament governs that. But if you had taken that trust, if you had taken that bank account that you owned individually and instead moved it into a trust or moved the ownership into a trust before you passed away, it doesn't go through probate at that point. Then it's governed by the trust document itself and doesn't have to go through probate after you've passed. So sometimes we use trust just to hold assets while you're still alive, so that way when you pass away, then the probate process is avoided for those assets. And then sometimes we also use trust to care for pets. We often talk to our clients about using trust and holding money aside to help provide funds for the care and housing of their pets after they've passed away. It's something that is relatively new. It's been in place in Massachusetts for about 8 years. But it's something we can do now, where we set up a specific trust and direct money into that trust on the death of our client. And then that trust is designed to make sure that their pets are receiving the type of care they're supposed to be receiving, and that the person providing that care and providing that, who's taking care of your pet after you've passed away is receiving some funds for that, and also has funds available for medical care and food and things like that. So we can use trust as a way to help protect our pets as well. So again, those are just a couple of examples of different things that we use trust for. And I'm going to talk about some other trusts over the rest of this discussion as well, and why we use those. So in fact, excuse me, 3 of the most common reasons why we use trust for our clients include the next category that I was going to refer to, which is what some people need. And that's the first one is a supplemental needs trust. So if you have a beneficiary, somebody that you want to have receive part of your estate after you've passed away, if they're disabled to such an extent that they're receiving government benefits as a result of that disability, often those government benefit programs are what are called means tested, which means that the person who's receiving those benefits would be disqualified from receiving those benefits if they received any assets, including their share of what you intend to be their inheritance. So instead, in those situations, we want to make sure that your assets are being passed into something called a supplemental needs trust. Sometimes it's also referred to as a special needs trust. The purpose of that trust is to hold assets after you've passed away for the benefit of this person. But instead of replacing the benefits that they're receiving from the government, it supplements them. There's specific language in there that makes it so that the assets are available for the trustee to spend on behalf of the on behalf of the beneficiary, but prevents the government benefits from being withdrawn. So that way the trustee is only spending money to supplement those benefits, not to replace them. They have the ability to say, we just want to make sure you're being taken care of. Here's a whole bunch of money, even if that means you're disqualified from those government benefits. But it's designed specifically to avoid that. And that's something that we often use. We work with clients who have kids who have disabilities, or grandkids who have disabilities, or any other beneficiaries, and having supplemental needs language built into their estate plan and having this trust set up in advance is really important to have. Another common type of trust that we talk to our clients about is something called an irrevocable life insurance trust. And I'm going to talk about this a little bit towards the end of our talk as well. But this irrevocable life insurance trust is a way to minimize potential estate taxes. So the idea behind the irrevocable life insurance trust is that it is designed to hold a life insurance policy. So you would create the trust and you'd move a life insurance policy into it, or it's going to go out and buy a life insurance policy. And because of the way it's set up, because of the fact that the trust itself owns the life insurance policy, when you pass away, the benefits, the death benefit that results from that life insurance policy, that death benefit will pass directly to your beneficiaries without potentially being subject to estate taxes. If instead of having that trust set up, you simply had a life insurance policy yourself, so not inside of an ILIT, an irrevocable life insurance trust, but you own the life insurance policy, the death benefits that are going to pass to your heirs are free from income tax. There's no income tax when your heirs receive the death benefits from a life insurance policy. But it's possible, if your estate is large enough to be subject to estate taxes, that the death benefit is going to be included in tax for estate tax purposes. And setting up an ILIT, an irrevocable life insurance trust, and handling it in the correct way, it's a very specific type of trust and there are very specific regulations there, but handling it in a very specific way allows you to avoid that death benefit from being part of the estate tax calculation. And that can be really important for a lot of our clients. So the third reason that we often use trust, and this is probably the one that I most commonly use these days, is to help protect my clients' assets against Medicaid and the Medicaid rules that are come along with potential nursing home care costs, right? So I want to talk about Medicaid. So in Massachusetts, the Medicaid program for nursing home care is run by an organization called Mass Health. So a lot of times you may hear Mass Health referred, but when we're talking about long-term care, it is a Medicaid, a federally funded program, a Medicaid funded program that is run through Mass Health. So what we're often thinking about when we think about long-term care is that it's very expensive, right? If you needed long-term care, if you had a catastrophic medical injury, right, and you needed long-term care, it can get very expensive very quickly. And I understand, none of my clients ever come to my office and say, I can't wait to go into a nursing home, but sometimes we can't avoid it, right? So we want to be able to stay at home. We want to be able to bring in care if need be, but sometimes we can't avoid a catastrophic medical situation, and we just need that type of care in a nursing home, and that gets very expensive. Often I tell people, especially up in the Hampshire County area, $10,000 to $15,000 a month, that's $120,000 to $180,000 a year for this type of care. So my clients often want to get assistance paying for that. They don't want to pay for all of that themselves because they don't want to take all of the money that they've been able to save and put away and spend it on their own care rather than being able to pass it down to their heirs. So when we think about getting assistance for Medicaid, for nursing home care, we're talking about asking for assistance from Medicaid through Mass Health in Massachusetts, but it's a Medicaid program. So that process of qualifying for this Medicaid program, it really boils down to a few steps. And I mean, it's much more detailed than this, but I summarize it in a few steps. The first is qualifying for Medicaid, qualifying for this assistance, right? In order to qualify, you have to need the type of care. You have to be able to show that you need this type of care because you can't provide for yourself. And you have to be over the age of 65. If you need this type of care and you're under the age of 65, there are other programs that help pay for that. Those are subject to different rules. But if you're over 65 and you need this type of care, we're talking about these Medicaid rules. So in order to qualify, the first thing is you need the type of care and you have to be over 65. After that, there's essentially a means test. This is where Medicaid says, do you have a significant amount of money? And if you do have a significant amount of money, then you have to pay for your own care. We'll help you when you're broke, but until then, you've got to pay for your own care. You got to use your own money to pay for this. So that amount changes depending on the family situation. If you are married, the amount that the threshold where Mass Health and Medicaid will start providing assistance is roughly $130,000. So you can have up to $130,000 in assets, and then still qualify for Medicaid. Okay, if you're unmarried, right? If you're widowed or unmarried for any reason, if you're just a single individual who needs nursing home care, that threshold goes from 130,000 down to 2,000. So Medicaid is really saying you've got to be broke. You've got to spend all of your money down before we're going to provide assistance. Okay. So that threshold, essentially, I liken it to them taking a a photograph, a snapshot of your assets at the time that you put in the application. They say, what do you have now, right? And they look at what you have and they say, is it above the threshold that's applicable to you? Is it above 130,000 if you're married, or above $2,000 if you're not married? And if it is above that, they say, sorry, go pay for your own care. There are a few things that are not counted in that snapshot. Okay. The first and biggest one is your personal residence, right? If you own your home, then that personal residence, that house, that real estate that you're living in is not subject to that initial snapshot. It can be if you answer the question wrong, but for most people, if you fill out the application, as you're filling out the application, if you answer the question correctly that you intend to return home, Medicaid won't force you to sell the house before you pass away. Okay. If you say I don't intend to return home, then they'll force you to sell the house. But otherwise, that's why we tell everybody, tell them you're planning on returning home. Even if you don't have the ability to return home, it's not a subject, or it's not an objective question. It's a subjective question. So it is where you are saying, hey, I know I might never ever come home, but I'm planning on coming home. So don't force me to sell my house. So if you answer that question that way, then the house and the value of the house up to a certain amount is not counted against you for Medicaid purposes. Okay. I see Liz is asking this question. So sorry, that's all right. So the house here is not included if you've answered the question that way. But I want you to remember the reason it's not included is because it's your personal residence, because this becomes important later on. Okay. So it doesn't count against that snapshot. A few other things that aren't included against the snapshot: personal property, your clothing, your furniture in the house, that sort of thing. Prepaid burial expenses are not counted against your threshold, and also a personal car, right? If you own a car, as long as it's not, some $200,000 Lamborghini, Medicaid will let you keep it and not counted against you. Okay. Everything else, unfortunately, though, counts against you. Any other real estate that you own, any money in retirement accounts, any money in your bank account, all counts against you. Okay. So in addition to taking that snapshot of what you own, many of you are probably aware of something called a 5-year look back period. Medicaid takes a snapshot of what you own, and they ask you what you've given away in the last 5 years, right? They have the ability to ask you what you've given away to anybody else as a gift in the last 5 years. And that creates a 5-year look back period. They're looking back 5 years to see if you gave away a bunch of money. And the reason for that is pretty obvious, right? Otherwise, if they couldn't do that, everybody would give away a bunch of money, and then the very next day show up at Medicaid's door and say, look, I'm broke, help me out. I need assistance paying for my care. And they want people to avoid doing that. So they have the ability to say, what do you have now? And what have you given away in the last 5 years? And that means that if you've given away any of your assets in the previous 5 years, you're going to get disqualified from Medicaid. They're going to say, sorry, you may be under the threshold now, but that's only because you gave away $400,000 a year ago, right? And if you gave away $400,000 a year ago, you don't qualify for Medicaid today. So the result of that is that I have to think of all of my clients, when we're thinking about Medicaid planning, as 5 years older than you actually are, right? We have to think of you, not what kind of medical care you need today, but what kind of medical care you're going to need 5 years from now, right? So that's the first step, the qualifying step. Snapshot of what you own, and what have you given away for the last 5 years? If you qualify for assistance, if you pass that first step, then you go on to the second step, and that's where they determine how much you have to contribute to your own care. Okay. So if you're married, the community spouse, and that's the spouse who's not in the nursing home, who doesn't need the assistance, the community spouse can have as much income as they want. The institutionalized spouse, though, can only have a certain amount. If that person is married and they're the sole source of income for the couple, they can keep, the couple itself or the community spouse can keep about $3,000 or $4,000 per month. Everything else, though, is over and above that. And if you're single and if you're unmarried, that amounts closer to $200 a month, right? You only get to keep about $200 a month. Everything else on top of those limits, whether you're married or single, is supposed to be applied against your nursing home care bill, right? So quick hypothetical. you're in a nursing home, and it costs $13,000 a month, right? You are making, so you, and by making, I mean, Social Security, pension payments, any annuity payments, any sources of incomes that you have on a monthly basis. In total, you're receiving $6,200, right? So if you're an individual, you get to keep 200 of that. 6,000, the remaining $6,000 has to go against your bill for a nursing home. So your bill, if it's $13,000, you pay the first 6,000. Now the bill's only 7,000. Because you qualified in step one, Medicaid picks up that $7,000, right? You've paid the first 6,000. Medicaid says we'll pay the other 7,000. They don't actually pay the full 7,000. They negotiate it down to about 60 cents on the dollar, which is why nursing homes are always, nursing homes are always complaining about how much the federal government's paying. But they pay enough and agree to pay enough, so that way the nursing home will agree to provide you those services. So now Medicaid is paying bills for you, qualified, determine how much you have to pay, how much Medicaid has to pay. Then Medicaid, you receive those services for as long as you're alive, right? As long as you need nursing home care services. And during that whole time, Medicaid is adding up all of the amount that they're paying on your behalf, right? And then you pass away. And that brings us to step three, right? So step one, qualifying, step two, determining your share of the payment, and then step three, after you've passed away, or after, if you're married, after your spouse has passed away, Medicaid gets to do something called estate recovery. That is where essentially they recover all of the money that they've paid on your behalf. They recover that against your estate. That's why it's called estate recovery. It's not very creative, but they call it estate recovery, or they recover that money that they've paid out on your behalf against your estate. So your estate, if you recall, is anything that you owned when you passed away, right? So if you have all of these assets and you've spent them down, but have excluded out the house, right? Remember in step one, we excluded out the house because you said it was your primary residence you're going to return. Unfortunately, after you've passed away, it's no longer your primary residence because you've passed away, sorry. But now that house is part of your estate because you owned it when you passed away. And if it's part of your estate, Medicaid is going to be able to take their money back from the value of the house before the value of the house. The rest of the value of the house is going to go down to your heirs, right? So in step one, it was protected, but in step three, it's at risk, right? So that's why I wanted you to keep in mind the reason why it was protected was because it was your personal residence. Not the case in step three after you've passed away. So when we're thinking about planning for this and trying to protect our clients' assets for Medicaid purposes, as I mentioned, we often have to think of our clients as 5 years older than they are. We have to be thinking about trying to take action early enough so that way we get past the 5-year look back period. Because essentially when I'm talking about protecting your assets, I'm talking about giving them away. I'm talking about taking money and assets that you have and moving it out of your name. So that way you don't own that asset, because if you own that asset, it's going to show up on that snapshot, right? In step one. If you gave that away in the last 5 years, it's going to show up as part of the 5-year look back period. So you've got to give those assets away, and then you've got to wait 5 years and a day before you apply for Medicaid. That's the idea. That's the plan that we often do for a lot of people. The problem is we don't know when you need Medicaid, right? Like we don't know when you're going to have a catastrophic medical situation that's going to require you to go into a nursing home. If we knew that, we could wait until 5 years and a day earlier and do all the planning, and then 5 years and a day later, you're protected. But because we don't know that, I often have to urge my clients to take action to protect their assets as early as possible and start the 5-year clock, right? So this brings me back to trust and why we use trust for Medicaid planning purposes, right? Often when we're talking about moving your assets away from you, we're thinking about moving them down to your beneficiaries, but that has some risk, right? Let's say you have a couple of kids, one of them's, potentially going to get divorced, and the other one's maybe in a risky situation or just isn't good with money or has a drug issue. Transferring your assets directly down to your kids while you're still alive is risky, because as soon as you've done that, that money is theirs, right? So instead, we often think about creating a separate type of trust and moving your assets into that trust, or moving some of your assets into that trust to hold the assets while you're alive. That trust triggers the 5-year window, right? So we've got to move the assets into the trust and then wait 5 years and a day. 5 years and a day later, the assets in the trust are now protected. But the benefit of the trust is that they're not yet the beneficiaries. They're not yet being distributed down to the kids, right? So we move the assets into the trust and we hold them in the trust until sometime in the future. Usually that triggering event is your death. And then on your death, we either hold the assets, continue to hold the assets in trust because we're concerned about, your kids' spending habits or anything like that, or we just distribute it down to your heirs at that point, right? But we're usually holding it in trust, so that way, for as long as you're alive, it's not technically your kids yet. So we use those trusts, or we use a type of trust in order to plan for Medicaid that way. We refer to it as a Medicaid Asset Protection Trust, because we're also very creative in our naming. And it is designed to protect your assets. And that's one of the most common reasons why I use trust these days, is to do that. There are other ways to plan for Medicaid, right? If you have long-term care insurance, that's a way to help bridge the 5-year gap. If you're a veteran, you often get different benefits, or have the ability to think about the Holyoke Soldiers Home or other veteran benefits. So there are other things that I talk about with my clients when we're trying to plan for Medicaid and trying to figure out how to bridge that 5-year gap. But often using a Medicaid Asset Protection Trust and moving assets into it as soon as possible is one of the ways we think about doing it. We don't always do it for cash, because you lose the ability to have control over these assets, kind of. And I'm not going to get too much into those details, because Sandy's already probably ready to cut me off shortly. But so you lose control over those assets in a significant amount of ways, and people feel uncomfortable about transferring cash that they have into that situation. But it makes a lot of sense for real estate for a couple of different reasons. So a lot of times we're setting up these trusts just to move people's houses into the trust, and then talk about potentially moving some other cash and things. So that's Medicaid in a real nutshell, right? Like, I mean, I go, I spend probably, when I'm meeting with clients, we spend anywhere from 45 minutes to an hour and a half talking about estate planning, and often 30 to 45 minutes of that is just going into more details on the Medicaid planning. But I wanted to make sure you guys were aware of it and some of the reasons why we use trust, or how we use trust to help plan around that. So the last thing I want to talk about, because I know I'm running short on time before we get to the question and answer, but the last thing I want to talk about a little bit is estate taxes. I mentioned this a little bit earlier when we were talking about irrevocable life insurance trusts. So I'm going to mention ILITs again in a second, but I want to just lay out the estate tax issue, especially here in Massachusetts. So on the federal level, many of my clients, in fact, none of my clients, are what we refer to as estate taxable, federally estate taxable. For on the federal level, you don't become subject to estate taxes until, as an individual, you're worth somewhere over $11.5 million, and as a married couple, you got to be worth over about $23 million. So I don't have none of my clients are hitting those levels yet, but maybe you are. Good for you. Congratulations. Call me if you are. But on the state level, right, in Massachusetts, we also have an estate tax, which is unusual. Most states do not, but Massachusetts does, and it is the most aggressive estate tax in the country. So the threshold where estate taxes start kicking in is $1 million. It's technically $1,040,000. You get the first 40,000 free, but just over $1 million is when you have to be concerned about estate taxes. And a lot of clients, when you're thinking about what's in your estate, and that's any assets of yours, including retirement accounts, the house potentially, life insurance benefits, as I mentioned, a lot of times clients are very surprised to find out that, well, if you look at their net worth, they're worth more than $1 million, right? And if they were to pass away, their estate might be subject to estate tax because of that. So real briefly, there's $1 million exemption that each of us has before the estate tax kicks in. The problem is, once the estate, if you've triggered it, if you're over that limit, you actually get taxed back on almost $1. It's technically $40,001, but the tax gets triggered back to that first dollar. So if you get over that number, you're suddenly subject to estate taxes. So we're always trying to avoid the need to trigger that estate tax. So a couple of ways that we either eliminate or minimize at the very least estate taxes. One of them is an ILIT. I mentioned that earlier. If you have life insurance policies or you're thinking about getting life insurance policies, placing them into an ILIT is often a great way to minimize your estate taxes, because if you've created the ILIT correctly and handled it correctly, then the death benefit doesn't get added on to the value of your estate for estate tax purposes. So that's one way that we often think about it. Another, it's a little more complex and we don't do it very often, but it's one way we think about it. Another very simple way is charitable giving, right? To the extent that you make charitable giving part of your estate plan, that's going to reduce the size of your estate and not be subject to estate taxes. And a lot of my clients are very charitably inclined, and that's great. And I help them, talk about what they're trying to accomplish, try to find organizations or groups that can help them accomplish that. Sometimes it's as connecting them with an overarching organization like the United Way or the Mass Community Foundation or Community Foundation of Western Mass, or specifically with an organization that's, I helped one client find a friend of mine actually runs a bunny rescue. And I had a client who loves bunnies and wanted to make sure that some of her monies went to support bunnies. And I connected the two of them and we wrote that into her last will and testament. And, that's often something that's very important. But charitable giving is a thing that would help reduce your estate taxes. Also, making lifetime gifts is really important to reduce your potential estate tax. It's a little tricky because there are different levels of gifts. As you may know, there's an amount that you can give to anybody each year without having to be subject to any IRS reporting requirements. That's roughly about $15,000 right now. So you can give anybody in the world $15,000 a year without having to report to the IRS. And that also is estate tax free. If you give more than that, if you gave one of your kids, if you have two kids and you gave each of them $250,000 and gave each of them $250,000, and then because of that, we're below the estate tax threshold of $1 million, technically the gift gets added back in. But then you would then trigger the fact that you owe estate tax, but you're only taxed on what's left, not the gift money. So lifetime giving is not a way to avoid the estate tax, but it's a way to minimize the estate tax, because the more you give away, the less is actually taxed in the end. So we often think about that. And then the last thing I'm going to talk about right now before we go to question and answer, because Sandy gave me a very polite 45-minute warning, is something called an AB or a marital estate tax trust. This is where, and this is the reason I talk about it last, because it's only available for married couples. But if you're married, what we want to do is make sure we are not wasting that $1 million exemption for the married couple, for the first spouse to die in the married couple, right? And the reason this is an issue is because there's no estate tax between married couples. So if you're married, when you pass away and you give everything to your spouse, there's no estate tax no matter how large your estate is. But then when your spouse passes away, they're going to have everything that you owned before. And then if they're over that $1 million threshold, they're going to be subject to estate tax, right? And what happened, unfortunately, is when you passed away, because we simply passed everything to your spouse, we wasted the opportunity to pass $1 million free of estate tax to somebody else, right? Because you get that free, you can pass everything estate tax free to your spouse, but you can pass $1 million to anybody estate tax free. And we've lost that benefit because all we did was pass it to your spouse. So what we often think about doing is using trust, again, totally different types of trust, because we use lots of different types of trust for lots of different reasons, but we set up a trust or a couple of trusts that are designed to hold and utilize the $1 million exemption for the person who passed away, right? So the first person who passes away, we essentially fill up a silo of up to $1 million in assets, and we make that ultimately pass on to the heirs, right? But we have some controls or some limitations on that. That means it's not part of the surviving spouse's estate. So when the surviving spouse passes away, they're going to be worth potentially $1 million less than they otherwise would have been. And by doing that, that person is going to be subject to a less estate tax. If your combined estate is worth $1.5 million and we've done it correctly, you can avoid the estate tax entirely because we split it equally and you're both estates are under that $1 million threshold. If your estate, say, for as an example, is $4 million, you're going to be able to pass $1 million of that estate tax free, and then the surviving spouse is going to be worth $3 million, and they're going to be subject to estate tax, but it's $1 million less in this. It's you're being charged estate taxes on $1 million less than you otherwise would have been, because we've passed $1 million over here when the first spouse passed away. So there's a little bit more detail to it, but it's a very common, it's something that estate planning attorneys have been using since the late 60s, early 70s to help minimize estate taxes. And we still use it. We don't often use it on, a lot of attorneys don't use that because the federal estate tax is so high, but because the Massachusetts estate tax is so aggressive, we're still using these marital estate tax trusts for married couples as a way to minimize people's estate taxes. And again, often they're referred to as AB trust. So if you happen to look it up at all, that's what they're talking about, an AB trust. And the reason for that is because you're essentially setting up two separate trusts, an A trust and a B trust. So that's everything that I wanted to make sure we covered. Sandy, I see you actually asked a question, and do you want to do this, or do you want me to